What are the 4 most common medical record analysis barriers that you encounter as a legal nurse consultant? I'm Pat Iyer. I'm an LNC business coach. I built from scratch and sold a thriving LNC business. Attorneys count on your detail-oriented ability to analyze medical records. These issues make your job tougher. Number 1, disorganized medical records. The records come into your possession in no order. Does this sound familiar? They were scanned and saved to a disk before they were organized, which requires you to sift through them to rearrange pages. You may receive multiple copies of the same record, or the paper copies are disorganized, requiring you to separate them into sections and rearrange the order. Or worse yet, the person who copied them used the double-sided feature but did not copy them in sections. You encounter a page of physician's orders on the back of a lab record, for example. It's inefficient and counterproductive to start a medical record analysis with jumbled records. To make sense of the records, you will most likely need to impose some system on the disorganized records, rearranging them, reshuffling them, relabeling them, possibly even recopying them or rescanning them. Point 2 is missing records. Suppose you get a much smaller amount of records than you expected. This could happen if the attorney's office asked for an abstract, a subsection of the medical records, instead of the full certified copy. In many situations, to evaluate the case, you'll need a full certified copy. This is particularly true when you're screening a medical malpractice case for merit, or evaluating a case as an expert witness, or summarizing the complex medical care that a patient required because of catastrophic injuries. Because of all those challenges, another reason for medical records missing is failure to copy or provide all the relevant sections of the medical record, even when a full certified copy is requested. For most attorneys, the medical record is just a stack of paper or an electronic file. The attorney relies on your knowledge of what should be in the record to recognize what's missing. Be clear and detailed about what's missing. I find attorneys prefer to receive a list in writing so they can work with a provider to get the missing documentation. Third medical record issue is illegible handwriting. That complicates medical record analysis. Right now, the medical record is typically a combination of handwritten and computer-generated records. The handwriting and signatures may be indecipherable to everyone, including the person who created the records. It may be necessary to get a transcription from the person who created the record. Some states have statutes that require providers to give a transcription at no cost. Your knowledge of medical terminology should help you decipher some of the difficult-to-read handwriting. If you can't determine whose signature you're looking at, in most states, the provider is obligated to give the names of employees who charted in the medical record. Number 4 is suspicious charting. Another medical record analysis challenge occurs when there are entries that don't make sense. They're inconsistent with other information in the chart, or they may have been added after the fact or changed. Using the detail-oriented part of your skill set, you may find it helpful to construct a chronology or timeline to identify the discrepancies. Inform your attorney-client about the issue so he or she may consider the legal implications of a possible altered record. Medical record analysis can be challenging enough without these barriers that I've described in this video. Communicate with the attorney when you run into these issues so that you can get the best records for your analysis. And be sure to subscribe to our YouTube channel so you can receive more videos designed to make your role easier as a legal nurse consultant. And head over to legalnursebusiness.com.